Hello friends, Namaskaram. In today's class, that is class number 2, I will discuss the protocol from section 491 to section 496 of BNSS, because in the previous class I have discussed the protocol from section 484 to section 490 of BNSS. As far as section 491 of BNSS is concerned, it laid down the process to be followed when the bond has been forfeited. It says that where there is a bond under the Sanhita is for the appearance or for the production of property has been forfeited, or it is in respect of any other bond under the Sanhita has been forfeited, the court shall record the reason, and apart from that the court will call upon the person who is duly concerned by such bond to pay the penalty thereof or to show cause why it should not be paid. So basically it laid down the process in theoretical sense, but in practical sense we have to note down that whenever a bail bond is forfeited, in that scenario show cause notice is issued to the concerned sureties, and they are having two options. Either they may bring the concerned accused before the concerned court and could claim discharge, or apart from that they may pay the penalty as per direction of the court. It may be in whole or maybe in part, it depends upon the facts and circumstances and discretion of the concerned court. As far as subsection 2 is concerned, it says if sufficient cause is not shown and penalty is not paid, the court may proceed to recover the same, as if the penalty is a fine imposed by the court under the protocol of BNSS. So we could say that the sufficient cause is required to be shown to evade the liability, and apart from that the payment of penalty is to be done to evade the liability of subsection 2. In case there is no sufficient cause, the penalty is not paid, the court may recover the entire amount as if it is a fine imposed by the court as per the protocol of BNSS. And even though the penalty could not be recovered, in that scenario, the concerned surety could be imprisoned in civil jail for a term which may extend to 6 months. Please be noted. Subsection 3 say that the court may remit any portion of penalty mentioned and enforce payment in part only. So basically we could say that the concerned surety could pay the amount in whole or in part as per direction of the concerned court. As far as clause number 4 is concerned, or subsection 4 is concerned, it says where a surety to a bond dies before the bond is forfeited, his estate shall be discharged from all the liabilities in respect of bond. Means before the forfeiture of bond, the concerned asset or property of the concerned surety could not be liable, and in that scenario it shall be discharged immediately. As far as clause number 5 is concerned, it says where any person who furnished security under section 125 or section 136 or section 401 is convicted of an offence the commission of which inter alia constitute a breach of the condition of his bond, or of a bond executed in lieu of bond under section 494, a certified copy of judgment would be the conclusive proof. In that scenario, the court may proceed against such surety on the basis of such certified copy unless the contrary is proved. The said section corresponds to section 446 of CRPC 1973. Now I am coming on section 492 of BNSS. It says about the protocol regarding the cancellation of bond and bail bond. It says without prejudice to the provision of section 491, where a bond or bail bond under BNSS is for appearance of the person in a case and it is forfeited for the breach of condition. Clause number A says the bond executed by such person as well as the bond, if any, executed by one or more of the sureties, in that case shall stand cancelled. So in case of forfeiture of the concerned bond, the surety bond shall remain cancelled, and apart from that, clause number B says that thereafter no such person shall be released only on his own bond. In that case, if the police official or the court, as the case may be, for the appearance before whom the bond was executed is satisfied that there was no sufficient cause for the failure of the person duly concerned by such bond to comply with its condition. So basically, if the concerned bail bond is forfeited, the surety bond will be cancelled, and apart from that, the said person will not be released on execution of the personal bond. In that scenario, the concerned person is required to show the sufficient cause. If it is not shown, in that scenario, he could not be released. So for which section 492 subclause B is quite important. So simply we could say that whenever there is a forfeiture in section 491 or in section 492 of BNSS, the sufficient cause is required to be shown, otherwise adverse action could be taken by the concerned court more effectively and in the dominant way. There is a proviso that says, provided that subject to any other provision of the Sanhita, he may be released in that case upon the execution of a fresh personal bond for such sum of money and bound by one or more sureties as the police official or court as the case may be direct. So basically we could say that the concerned person could not be released on the personal bond in case the previous bond is forfeited. In that scenario, he is required to execute a fresh personal bond with one or more than one sureties as per direction of the concerned official or court as the case may be. The said section corresponds to section 446A of CRPC. Please be noted. Now we are coming on section 493 of BNSS that says process in case of insolvency or death of surety or when a bond is forfeited. When any surety to the bail bond under the Sanhita has become insolvent or dies, or where the bond is forfeited as per the protocol of section 491 of BNSS, the court by whose order the bond was taken or the magistrate of first class may order the person from whom such security was demanded to furnish fresh security in accordance with the direction of origin order. If such security is not furnished, the court or the magistrate as the case may be may proceed as if there had been a default in complying with such order and inter alia the person could be imprisoned. So basically section 493 laid down the special case where the concerned surety got insolvent or die or inter alia the bond is forfeited. As far as section 494 of BNSS is concerned, it says when the person required by any court or the officer to execute a bond is a child, such court or officer may accept in lieu of a bond executed by surety or sureties only. So basically in that case a personal bond could be accepted without any surety or sureties. As far as section 495 of BNSS is concerned, it says all order passed under section 491 shall be appealable. And as far as section 496 of BNSS is concerned, it says the High Court or Court of Session may direct any magistrate to levy the amount due on a bond for the appearance or attendance at such High Court or Court of Session. Basically it is concerned with process, but in practicality it is not of having any practical use. So I think that I am totally able to cause all of you to understand the basis of bail bond and how they are required to be submitted. And apart from that, I have discussed the special cases, means the case of forfeiture. And apart from that, I have discussed the cases where the penalty is to be deposited in case of forfeiture and there is no sufficient cause. See you in the next video. Till then, Jai Hind, Jai Bharat.